You're listening to the Valley Current.
Jack, hi, how are you?
Pretty good, Rafael. Welcome into the Valley Current. I'm always amazed to look at your background. Or it looks like a bunch of seafood or something.
Some crab is in there.
It does look like that, doesn't it?
It's a detail from a much larger work.
Wow, it's beautiful. I love that. Is that a painting or what? What are we looking at?
A collage.
Wow, that is something.
Oh, I thought you knew about. Didn't I give you one of her books?
You did. I remember the book. I think she's quite an artist.
This is Root Series 15, detail from the middle of it.
Wow, it's quite beautiful. So does she have her own studio, or where is she doing work?
Oh, yeah. She had a big studio, which we just closed when the pandemic began because she wasn't making big works anymore. Now we have one in the house.
Nice.
And we're still thinking about what to do.
What to do in terms of going back to normal?
Going back to normal, maybe getting a bigger studio. You know, a lot of her works over the last 10 years are on huge pieces of Mylar,
right?
3.5 feet wide and 8 feet high.
Wow.
But she's making smaller works now, so we'll see where it goes.
Beautiful. So you're married to an artist and you're an intellectual. And I like to say that you've done a book that I use all the time. So I want to give you a little bit of promotion here because I think your book on fiduciary duty law is the book, The Law of Fiduciary Duties. And you've got a website, fiduciaryduties.net, which allows a buyer of the book to get access to the content online. I think you did this setup yourself using an IBM tool. Am I remembering this right?
Lotus Notes is the basic software. I had help setting this up.
It's beautiful.
But it's good. And, you know, it has a lot of features that people don't always realize. It has concept maps and links of all kinds. It's a specially advanced ebook.
Yeah, I mean, Lotus Notes was popular, and then I think IBM bought Lotus, and I'm not sure what happened thereafter, but it's amazing.
An Indian firm called HCL bought it.
Oh, okay.
And now operates it.
Okay.
And it may be nearing the end of its life, to quote your program. We'll see. We'll see.
So you pay a subscription fee for an online version of Lotus Notes.
Correct.
It's still called Lotus Notes, like literally?
I think it's still called HCL Notes now.
Okay.
Or HCL, Notes. And it has a smartphone accompanying application.
Right.
So it still is a great system for organizing your life. Mm-hmm. And when I get a new client or a new matter, I still create a new database in this system. For example, so these are the categories. Mm-hmm. And if I look for something under this, if I look for some Supreme Court stuff, I find this. You know, that's the way I build this stuff. And all my clients have one of these.
Beautiful. So you really are sort of an electronically savvy lawyer using these tools, because a lot of
I was in the computer business before I became a lawyer.
Right. Mm-hmm.
Artificial intelligence. I was very advanced. But right now, it's funny you should mention, I did some software about 10 years ago for my wife's art, and I got some new ideas, which I want to program now. Mm-hmm. And I'm struggling right now with what software should I use to make something that Adobe Flash used to support, but no longer. I want to make something like that and go back to programming, which at my age gets harder, but we'll see what I can do. Well,
you challenge yourself and the skill returns. You get back on the bike and you ride it. You remember how to ride it, hopefully. But you did something really interesting because, I represented back in the day, many decades ago, VisiCalc. And
yes, I remember them.
Was the original spreadsheet. This is back when it was Davis, Stafford, Kelman, and Fenwick. We started Apple Computer. We also started the company that became VisiCorp. Its name originally was Personal Software, Inc. They had this product called VisiCalc. Actually, it was a joint venture between them and guys on the East Coast called Bricklin and Frankston Software Arts. And VisiCalc was the reason the Apple II sold, because it worked on the Apple II as like one of the first spreadsheets.
Right.
And the interesting part is a guy worked for VisiCalc that started Lotus. Mitch Kapoor was an employee of VisiCalc, and he wrote the trending graphing product called VisiTrend or VisiPlot or VisiGraph, or maybe all three. And he was an employee, and he thought, hey, there's a better spreadsheet out there to be created. So he left. California doesn't have any non-compete laws. I mean, he left. He was free to do what he wanted. He came up with Lotus 123, got funding from a venture capitalist in New York, a famous guy whose name will come to me in a minute. And Rosen, I think was his last name, Peter Rosen or Jeff Rosen. I'll find the name, but basically the guy put $5 million in to help him get started. And he just zoomed, and Lotus became a big company. And the follow-on product that was supposed to really take them to the stratosphere was Lotus Notes, which is the product that you're using. And I could tell you lots of other stories about that, but it's sort of like the way the industry progresses. These people learn, and then they want to improve and make things better over time.
Correct.
And they do it over and over again. And you are, even though you're kind of my vintage, which you've been around for a few decades in law, like me, you like to imagine we as knowledge workers should be able to use the amplification tools that the software gives us. Yes. And when we do that, we enable our clients to get better service and ourselves to sort of use our brains as opposed to where's that piece of paper and why can't I find it and that sort of thing, right?
Yeah. By the way, you've lost weight.
I have. I've been on I wouldn't say an extreme diet, but I've been doing about 3 hours of exercise a day. Starts like at
3 hours of exercise?
Yeah, 3 hours. It starts with a bike ride that goes about 15 miles on a bike. And then from there, it shifts. I'll see if I can get this on the screen. It shifts to a yoga studio, and that's me in the yoga studio.
Okay.
For another hour. And then there's a bike ride back. And then usually in the afternoon, I go swimming for another hour. So collectively, it's about 3 hours. And as a result of that, I've restricted myself to just 2 meals a day. I skip breakfast, which a lot of people think is bad, but I think it's good. I have a late lunch, and then I'll have something really light at about maybe 7 p.m. And I find that by skipping one meal and trying to create a longer fasting regimen, you do see the weight come off. And my goal is actually to get to sort of my college weight, which is probably another 30 pounds.
Really?
That's when I was really just totally, you know, these days the calculations are so difficult to figure out.
They are.
Some people think it's much more about your muscle mass. And so you can have weight, but it's got to be more muscle than fat.
Right.
That's the big kicker, which is how do you figure out? So you have to lift weights as well. I do a little bit of that, not as much as I probably should. But yeah, my goal is to get back to this sort of image of myself when I was mostly muscle.
Good.
So yeah, it's been an effort. You look like you've lost weight.
I did. About 2 years ago, I meditated and changed my diet. I've lost 75 pounds and kept it off. And I still want to go another 5.
Wow.
So
you gotta be proud of that.
Proud isn't the right word. It's just serious about it. And I'm not doing, because of the pandemic, I caught COVID before people knew what it was. I got all the symptoms. I was in bed for 2 weeks. And because of my age, I lost a lot of muscle mass, and I'm struggling to get it back now. Mm-hmm. But I'm healthy in terms of walking around and doing everything. But I could use some of your procedures in my own life.
What you find, and it took a while to really feel this way, you get so used to the drill that you miss, like if it's raining out, therefore you don't get on the bike because this is biking outside. Right. you kind of feel like, God, part of my life is missing, because getting on that bike and being in the sunshine and feeling kind of the miles go by, it really does create this habit. And you start to realize that, a new client is not as important as your exercise drill. So
yes.
I'm sure I've given up a few clients that have called me urgently, and I just ignore the phone because I'm on the yoga floor, and then I call them back and they say, "Oh, I found a lawyer. Thank you very much." And it's like, okay, that's the way it goes. I mean, years ago, I would probably be in pain about that. Now I'm like, hey, that's fine. I've got my priorities right.
Okay.
I mean, it doesn't get easier over time, clearly. And my way of thinking is you really have to put your health first. That's sort of like foundational to everything.
I agree. You're in your 60s?
I'm in my 60s. And, it's when I look back at some of the images, because I've been looking back at photos of what did I look like 10 years ago, 20 years ago, 30 years ago, 40 years ago. I think to myself, man, when I was in law school, I was a real buffed animal. I mean, I was an athlete. I mean, I really had a lot. I'm going to see if I could find a picture. I doubt that I'll find one, but I was really sort of an athlete, and I knew how to stay athletic. But these days, of course, when you go into law school, everything seems to change.
Does change.
I mean, it's amazing how that works, isn't it? You start to realize that you're leaving a lot behind.
Yes.
And it kind of gets us to this first topic that we have, which is how it really is health related. And we're talking about this Texas statute that seems to now have gone viral. There's a few other states
I see
that have picked up on it,
including California.
It's an interesting thing to imagine that we can see what might become a group of states that decide to use this method to enforce something that I think historically, but I've always thought it's a pretty private decision. What happened?
You're talking about abortion.
Yeah, abortion's a very private decision, right? I mean, it's really...
Well, okay, because of you and this, I reread Roe v. Wade.
Yes.
I don't know, have you read it lately?
I haven't read it lately, but I remember reading it
in law school.
In law school and spending some time with it. And I remember discussing it. I remember discussing at one point my mom, because my mom left the Catholic Church. I was raised Catholic. And I said, Ma, she recently died. I said, Ma, why did you leave the church? Because my dad was a big believer in the Catholic Church, a big church attendee. And she said, they just don't realize that women need to decide what the right thing to do is, including birth control. And I found their position to be kind of anti-woman. I mean, that was her view. And I can't tolerate the hypocrisy of men controlling women, and that's the Catholic Church. That was their view. Of course, my dad was completely opposite her view.
Sure.
I wanted to show you this picture. This is what I look like in law school, just to give you the flavor. It's a bad image.
Great.
It's pixelated, but that's the guy with all the hair and the big smile and the tan. That was, I think, my picture from my first bank account card when they had the ID card down in LA at UCLA Law School. There was a local bank. It's out of business now, or maybe it's been merged into something. And that was the picture they took for that card. And it was my first California bank account, having moved from New York to go to law school. So I thought you'd get a kick out of that.
Well, you must have been good looking, because I saw a picture of your wife, who's beautiful.
Oh yeah, she's gorgeous. She's something. Yeah.
Does she help you exercise or do it with you?
She's a big athlete. She's got like no body fat at all. She's just, and she can outbike me. She can outrun me. She can outswim me. Maybe she can't outswim me. I think we're close on the swimming side, but she's quite an athlete. And yeah, it's a real motivator when you have someone that's with you doing it. But yeah, to turn to this health thing, I always thought that the decision in Roe v. Wade was, I think it was Justice Blackmun who wrote the majority decision.
I believe so.
And I always thought that it's such a tricky area to get your finger involved in. And in many ways, once you decide to get in it, because you are setting a standard for the entire United States, there's going to be some backlash because we do still have 50 different states. We do have almost 50 different cultures, not quite that many, but enough. And certainly many different religions and very many different religious beliefs about what should happen. And even within the religions, as my mom is a good example, a lot of dissent. And I always thought as I grew up, even though I grew up Catholic, that, hey, if I were a woman, I'd want the right to choose. I'd want the right to control it. I'd want the right to make the decision. I mean, it's such a big decision. And of course, I went to a Catholic high school that was pretty strict as well. And they would like, no, that's bad law. That's not appropriate, blah, 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 blah. And so now we have kind of the full circle of what's going to play out with state law that is legislating, kind of trying to get, I guess, a loophole, you could argue, or you could argue to get an enforcement mechanism, because we're talking about the Texas law that's SB 8, right? Isn't that what it's called?
It's Senate Bill 8, and it's their Health and Safety Code 171-201 and following.
Right, Texas Heartbeat Act, right?
Yes.
The name of it.
But, all this talk in the courts and in the news about private enforcement is not really accurate, because a civil action is, while it can be initiated by a private citizen, you need courts to carry it out.
Sure.
So what the Supreme Court really did here was sort of kick the can down the road and say, we're not deciding constitutionality of the statute. We're going to wait till a real case comes before us.
Right.
Which led me, when you and I first talked, led me into a study of standing and the history of standing law,
right,
which is really complicated. But before we leave Roe v. Wade, I recently, in preparation for today, reread Planned Parenthood versus Casey.
Okay.
I don't know if you've... Now, that's a 71-page or 91-page opinion.
Right.
And I'll tell you, the prospect that Roe v. Wade might be overturned is not a far-out prospect at all. Roe v. Wade is not a clear statement of law. And the whole concept of the viability of the fetus, which is what Roe v. Wade turned on, that up until the point of viability, the woman's rights trump the state's.
Right.
But once viability hits, the state has rights.
Right. It's almost like the woman's body is still the woman's body until viability. And at that point, there's a being. But and the being has rights to be protected by the state, right?
So they say, although the being is not yet a life until it's born.
Right.
But yes, the state has a legitimate interest. However, the point of viability is moving closer and closer to zero these days.
It's almost like the flip side on what does it mean to keep someone alive at the very end of life, right? It's almost like that's the flip side, beginning of life, end of life. It's all stretching out.
Yes.
Because we have all these tools and equipment and technologies to keep something breathing, something going, right?
So there's a Mississippi case that seeks to overrule Roe v. Wade, Dobson or something.
Right.
And I read the briefs in that case. They're pretty stupid, and they don't really take consideration of Planned Parenthood versus Casey, which is a very lengthy... Roe v. Wade and Planned Parenthood are deep philosophical documents.
Right.
Frankly, they don't sound like legal opinions at all. They're more like moral texts.
Right. Right.
It's a very complicated area, but standing is yet another complicated area. What does it mean to allow a citizen to walk into court and file a lawsuit where he has no interest? And this brings us back to the point. You're familiar with Blackstone's commentaries, right?
Sure, of course. Mm-hmm.
Okay. He makes the distinction at the beginning between private wrong and public wrong.
Mm-hmm.
Public wrong is criminal statutes.
Right.
Private wrong is the rest of it.
Right.
But the distinction between private and public is not all that clear. For example, murder, private or public? Both? What is it? Why don't we have a Texas-style statute for murder? And why would anybody object to that? And that brought me back to the old thing about the Ware Guild, in Europe. paying for the death of the person you murdered, if the family accepted the money. Arab law has one of those. Okay. It's a really long, it makes us start to think about the role of the state in our concept of right and wrong and justice.
Right.
And that role, you and I live in America, and America has a very prominent role for the state.
Right.
Many authoritarian states also have a prominent role. But something like India has less of a prominent role. There's honor killing and revenge killing. Mm-hmm. So it is to me, it is a very, very complicated area of the law, and I'm still unresolved about it after reading all this stuff in your honor.
Well, I appreciate you doing all the work, because you're far more informed now than I have probably ever been. But conceptually, just setting out that model of the role of the state versus the private individual. Yeah. The Bill of Rights that exists are meant to allow the private individual some degrees of freedom away from the state. But even within the role of the state, we have the role of the federalized state, which keeps growing, and the role of the individual 50 states to decide their own laws, because the concept, and people forget this when they look at what goes on in America and what goes on in the minds of Supreme Court justices, the modern experiment that the United States, all 50 states, represents is, hey, if you don't like living in Texas, you can pack up, get a U-Haul truck or do something and move to Oregon or California or North Dakota or South Dakota or Wyoming, and find whatever freedoms that you can find based on whatever research you choose to do.
Right.
And there's some degree of notion that everything just will work out better if you give people that degree of mobility to choose where to live. So obviously the right to travel is itself a constitutional right and represents this idea of you can move from one state to another. Of course, whether you can leave its tax regime, because they follow you, is another question. But conceptually, you should be able to pull up roots and say, I was in New York. I'm a New Yorker for the first 20 or so years of my life.
Yes.
And then I got admitted into law school, and I moved to California to go to law school.
Right.
And stayed with the view of, hey, I'm going to practice law here and take the bar here. I still also took the bar in New York and toyed with the idea of moving back to New York, passed the bar in New York, toyed with the idea of moving back to New York, but ultimately decided to stay in California. Now, recently, I may have mentioned this to you, because of my mom and her illness and my brother's death last year.
Year before last.
Yeah, the year before last. Then my mom was last year. I moved to Florida. I took the Florida bar and, just bought some used outlines. My wife was laughing. She said, "You're never going to pass it. You're not taking it seriously." Did the study, did the work, took the bar exam, passed it. She was shocked. She said, "I didn't think you studied enough." And I said, "No, I did." And, I look back and I say, you have freedom to do a lot of things. It may take a lot of work to do it, but you have freedom to do it. I wanted to show you these pictures before we get back to this. This is my mom and dad in 1951. Their anniversary, their 72nd anniversary, now they're both deceased, would have been in April next year, April 8th, 1951. So I guess it would have been the 71st, 2022 would have been the 71st. So they're that beautiful couple. And I wanted to show you. So this is this beautiful young woman. She was all of maybe 20 years old. My dad was like 25 at the time. So I wanted to show you the picture of them, of my mom at the very end, because this is like the normal aging cycle that we all go through, right? It's just part of life. But this was what she was like towards the very end, like literally. So, this is how life ends in America. Of course, you have all this equipment around you. You have all you follow, you lose all your hair, you lose all your muscle mass. And then you have a bunch of medical people around you with a bunch of equipment. And that's her at the age of 90. like literally in her last year of life, being supported in a hospital bed and all the rest. And, that life passes pretty quickly, and this beauty just goes away. I mean, you could be the most beautiful person in the world, and there's nothing that's going to stop aging as we know it. Although there's
actually, I've been reading about things, steroid cocktails and so on. Jeff Bezos is taking some. Elon Musk is taking some. I've read.
Right.
They're supposed to do something. I'm not sure.
Yeah, they're all into a view that they want to live forever. They certainly have enough money.
They have enough money, but that's not really the whole point, is it?
Right.
But I like your idea. I listened to your talk with that doctor, and of course, reimagining health practice as preventive and sustaining personal growth instead of just healing is wonderful. What's the analogy with law? Where do you go with that?
Well, so part of it, of course, lawyers for a long time have said, if you come to me in advance, I can write contracts for you. I can get you into a limited liability entity, a corporation, something that's going to protect your wealth. That's the whole concept of why people incorporate. Of course, most of them don't do it the right way. They don't keep the right records. They don't do the right minutes and resolutions. We know all that. But conceptually, this idea that disputes should be resolved without help from the courts, like the court is like the last resort.
Right.
Really the court represents everything else has failed.
Right.
And most judges think that way. In fact, I think most judges, when they see a case, they wonder, why is this case here?
Right.
What failed? And I want to relate I'm going to answer your question, but I want to relate it to the topic of this Texas law, because you are enabling a whole body of new case filings when you pass a statute that essentially has a bounty hunting aspect to it, which is really an interesting thing to set up. Because once you do that, you enable bounty hunters, litigation lenders, lawyers with time on their hands, lawyers that have moral convictions, whatever they are, all sorts of things to generate new case filings. And we've seen that, of course, in many different variations. The federal courts are going through it now with this American and Disabilities Act stuff, where there's just volume filings. They've automated all the pleadings. I only know this. I don't practice in that area, but I only know this because I've acted as a mediator for the federal courts. They've got so many of these cases, they're trying to push them. They actually stay the cases and they stop all discovery because they don't want the legal fees to run, which becomes the big remedy that the courts have to deal with. And of course, judges hate to review and fly spec legal fee petitions. It's a waste of their time. So conceptually, the party files it. There's now a local rule in the Northern District of California. The case gets stayed until there's a very specific evaluative process that involves like taking pictures of the site, getting all sorts of facts stipulated to. So think about that. I want to use that analogy because in many ways you could say the court is saying we're really a last resort, but of course the plaintiffs and the plaintiffs' lawyers all want to start the meter running because that's how they're going to get a remedy out of this. Because in most cases, these small businesses are like, leave me alone. My ramp is fine. The paint is fine. The sign is fine. And a lot of these are small businesses. And of course, the plaintiffs don't care. They file the suits almost like one after the other after the other. In fact, there's a guy named Scott Johnson. He's been in the news. He has like this motorized wheelchair. He's a sad case, quadriplegic, was a lawyer. Now he's mostly a plaintiff in like 8,000 of these, a huge number of these cases. It may be less than that, but it's a very big number. He literally rides his electric wheelchair from business to business along El Camino and just stops in saying, I want to rent a room here. By the way, there's no counter for me to sign the contract. The counter's too high. Takes a picture. He's got this thing down to a science. I mean, literally, he's keeping probably several law firms busy. And of course, those law firms are like, hey, It's a federal statute. It was passed by the first Bush. So it's not like it's a Republican piece of legislation. It was signed by George W. Bush. And we're enforcing it. And people have to get in line. And this is just normal. So I worry that we've created, or Texas may have created, and then it's going to get replicated, this amazing viral set of legislation that's going to put so much of a burden on the court system. And I just don't know how far the courts will go in trying to figure out how to handle these cases, right?
Well, I still think there's a good chance that when the first case actually comes to court, it will be thrown out because of standing problems. There's a chance. This is by no means certain, but are you familiar with Lujan versus the Wildlife Federation, holding that when Congress passes a law giving an individual citizen the right to file a suit, it's not enough that the law exists. The citizen has to show some connection with the thing he's suing over.
Right.
Now, in this case, characterizing abortion as a private wrong or a public wrong is not an obvious thing. Like murder, public or private. Seems like public because there is no plaintiff. Same for abortion. But Texas is treating it as a private matter, which doesn't really fly, in my opinion. So there are a lot of philosophical standing issues to be resolved before it really goes somewhere. The other thing is, if you file a case, you can get your costs and attorney's fees. If you lose, the other side can't get costs and attorney's fees. That's bad.
That seems fundamentally unfair. In California, of course, we have a statute, Civil Code 1717, that says
1717, right.
In contract cases, you must have it be mutual, or the
Correct.
law makes it mutual.
Correct.
Regardless. And of course, that's been viewed as a very good thing to kind of create some symmetry.
Correct.
But I can tell you there are lawyers that draft contracts in California that select New York law and then say that the landlord, particularly in lease cases, the landlord will get his attorney's fees. And they try to skirt that mutuality principle. But most California courts have said, hey, if the real estate is in California, you can't just select New York law and think you're going to skirt around these protections, because the law just won't allow that sort of selectivity in a case where, the res itself, the real estate, is right in California.
Looking back over the centuries, the idea of letting anybody who wants to file a lawsuit started in Athens, as I wrote you, Solon. That's why I'm thinking of writing an article about this called, Texas needs a Solonoscopy. It started in the 6th century BC, and then it fell away in, I think, the 3rd century BC. And over the centuries, there's been all this law about barratry and champerty.
Right.
And also, the machinery of the state was centered in one authority figure like a king. So all the standing issues that we wrestle with today and that the Supreme Court wrestled with in this case, they didn't exist until the founding of the United States. And they all have to do with the complicated interaction between state legislature, federal legislature, and so on. So I think, thinking over the whole history of this and where it's going, they were very concerned at all times. There were many people who said, we shouldn't give everybody the right to sue. We shouldn't give them bounties because they'll flood the courts. I haven't read about flooding the courts yet, except in our contemporary world, where I'm aware of many floodings of the court. For one big example that I always notice is slap motions. Right. When slap was brought in, it was meant to shorten litigation. Right. No way. Every case now has a slap motion.
Right. And an appeal. And the case, and it's almost created its own industry of activities, right? So you could say this body of what's currently Texas, but it'll probably be adopted in 10 more states before something actually happens to curtail it. It's going to create treatises, like whole treatises of how this legislation will operate, if it is allowed to operate. and then how courts will manage what goes forward. And of course, along the way, the real effect is who wants to practice medicine anymore that involves abortions if you're going to get sued and be wiped out. Like if you're a doctor and you spent all the time and money getting through medical school and passing your medical boards, and you have a world of choice as to what direction you choose, gynecology, prostate issues, you name it. Who's going to go in an area where all of their folks, all their friends who have been in this area said, I just got sued. I can't believe it. I have to spend a fortune. I can't get insurance anymore. I mean, I just don't know. I mean, look, doctors are human beings. A lot of them are my friends. And they say to me, legislation like this is really meant to scare doctors out of fields of practice. And ultimately, women will pay the brunt of that. I mean, that's really what happens. There'll be less doctors practicing in the area, right?
There have been several news articles about how Texas abortion industry has absolutely shut down, and people are going to, I think, Arizona and Colorado to get abortions. Sure. And many women can't afford it,
Right. I mean, you could argue what actually plays out is those that can afford it can get on a Southwest Airlines flight or a bus, Greyhound bus or train or whatever, and make their way to another state and spend the night and do what you need to do. And so it's not like an absolute deprivation, but for a woman who can't afford that because she has a full-time job and maybe she has other kids and there's so many complicating factors.
Right.
It's amazing. Texas has done something that will likely have some real repercussions on lots of families. You gave a good example of a situation where the husband or the boyfriend wants to have the child, and then he becomes the plaintiff in the case. I mean, that just sounds absurd to me, right?
Yeah, but it could happen.
Right.
Either the husband or his friend can sue. Also, as you point out, disputes between the spouses over whether an abortion should be had. How are those handled today? Without this law, they're already rather contentious. But the woman has a right.
But I think most judges, at least in California, that I've heard, are like it's really not the husband's decision. Like the husband doesn't really have a veto right. I mean, he can try to use persuasion, but fundamentally, it's not his body.
Well, this is 3 pages of discussion in Planned Parenthood versus Casey talking about this topic, agreeing with what you just said.
Right. And so, so conceptually, when you imagine the authors of this legislation, did they actually think through all of the percolating repercussions of this stuff, or is it?
I can't imagine it.
I mean, it would fill up a flow chart that would be so immense. And you have to wonder, did they do anything like that in their thinking? Or is it more like, no, we just want to make a statement here. We want to make a statement here that we're going to do something, and we're going to do something that gets passed, and then we'll see what happens.
And don't forget, Roe v. Wade was Texas. That was their law.
Right.
So they've been at this for quite a while.
Right.
But we'll get a ruling on the Mississippi case, I think, this summer. That's what I've read. Mm-hmm. And we'll see where it ends up. It's not obvious to me where it will end up. And I have strong feelings of my own, but I understand that's not what you and I are talking about. We're talking about the legal side of it.
Yeah, I mean, the legal side of it is interesting because you have the fact that it's a state statute, which states typically, subject to individual rights. And the individual right we're talking about is this privacy right that a woman has, a man has too, but it's not explicitly in the Bill of Rights. You have to tease it out based on this view that it's implied.
Penumbra. It was a penumbral right.
Right. It's sort of like it's there. It's the right to be let alone. The right to the privacy of your thoughts and presumably the privacy of your own actions that you can choose to do.
Well,
So,
intimate relationships and so on, the government shouldn't get involved.
right.
And you and I are brought up in that era where we believe this, basically. But this is not the history of the law by any means, even in America. This is a 1950s and forward movement, which now is getting kickback.
It's getting kickback even to the present day because, of course, Judge Ketanji Jackson Brown is going through, or Brown Jackson. Yeah, I guess it's Brown Jackson. Let me
Brown
get
Jackson.
Right. Yeah, Brown Jackson is going through hell. And a lot of crazy remarks are being made, like maybe the Loving case was wrongly decided and we shouldn't have had some constitutional right of blacks and whites to marry each other.
Right.
And it's just like, what are we in the 21st century? I mean, it's just shocking to hear this.
We're not in the 20th century anymore. And I realized, I went to Berkeley in the 1960s. Mm-hmm. And then I went to Boston University Law School.
Right.
And in the early 70s, because I dropped out for a few years while I did computers.
Right.
That was a special era. And I have certain attitudes that I acquired then. Mm-hmm. It's very hard for me to outgrow them or to get beyond them.
Right.
But this kind of law brings it all to the surface, doesn't it?
It does. And I think it's going to remain contentious for probably the next decade or more, absent some sort of unifying theme that plays out as a result of the world becoming far more intelligent with artificial intelligence. Like if you imagine.
Stay tuned for part 2 of this episode of The Valley Current.